All right, it's 7 o'clock. Great, perfect. April 17th. Thanks for joining. Aceofcoins.com is my core website. Aceofcoins.club is a video series. I do casework, and then some of those strategies that I come up with that actually help people, I publish those in a video series. So you can actually go and learn and see what other people have used over the years. And I always keep them updated. I always add content, and we got new things once in a while. So let's see here. I'm still interacting with Zoom. I got to check the screen here. So I wanted to cover a couple things today, but first I have a written list, but I just want to mention that when I did the 3-week series on Saturday talking about the False Claims Act, my idea was to explain to you, anyone who wants to, make a claim for under the False Claims Act for someone who received federal funds. And there's plenty of targets out there. It's unlimited. You'll never be able to do it in your whole lifetime. So I spent several hours on 3 Saturdays, and I put together the complete collection in my mind, the complete set of things you need to do that, to go and file a case. And my thinking is, if you were to go and do that and file the case and then not know what to do, my thinking is some of you would come back and say, hey, let's have a discussion, in which I'd be happy to have a discussion, and have more content and just kind of guide you along until we covered most of a type of an example proceeding, maybe doing some gaming and things like that. We get some people in there and have a discussion. But so my thinking was, all right, we're going to have like 12 people on those calls. But on each Saturday, we had like 65 people. And I was really excited to see so many people were interested in that. And all those people, by the way, y'all should have been given access to the membership. We sent emails out several times. We had some difficulty there. You can email my partner, Jim, Mr. Bolins at Proton Mail. I think it is Mr. Bolins at protonmail.com. If you haven't been, added in there, but you should be able to have access to everything. I think he even has a video.
Really cover a couple things today.
Yeah, even has a video on that. So I might have to mute everybody again. But anyways, so out of all those people that were there every Saturday, guess how many people have subscribed, are reading or watching these videos? There's 12. And no one that I know of has filed a case. I like to ask, what is going on? Why am I even saying all this stuff? That you could put, if I don't care if maybe you don't care about this. I don't know. I'm not concerned about what your interests are, but imagine if you found a situation where federal money was being paid out to somebody that you thought was getting it illegally. All right. And you're watching the news and you're saying, well, that's not fair. I just showed you how to file some papers in federal court and do something about it. Imagine if you want to even have a voice, right? You start a case like this, your best buddy is Pam Bondi, the DOJ. And you could put yourself in the news cycle if you care. Maybe you don't have to if you don't want to, but I'm just saying, if you want to say something about what you think is an improper use or the fraudulent false claim of federal funds, there you go. That's how you do it. We have a private right of action, which I'm going to get into some aspect of this later on. And it's going to be coming from this call, and I'm going to bring it in next week. But I just wanted to mention that and ask the question, why hasn't anyone filed a case? Pick one. You're watching the news. All right. Maybe is there an answer? No, I don't care. It's a rhetorical question, right? You guys, come on.
Well, people are saying that they've watched the videos and I'll just kind of condense it, maybe a little leery of doing this by themselves. They're interested in pursuing it, don't really know how to get started. They're even wondering if you should give them a list of targets.
Shit. If I do that, I want a big fat percentage of your winnings. Yeah. So do you really want that? I mean, it's a lot of money, so.
Yeah. Also, someone is saying, is there a consequence to filing these cases on your social score? Social score.
No, I don't know what that means, but no, we don't have social scores here in this country yet. Not really. I mean, not officially.
Yeah.
Stop worrying about the consequences. I told you guys a long time ago, you can't get anything done if you're always doing that.
Okay,
I
and I'm
need,
just gonna put,
what?
say Jim's address again, I'll just type it in the chat so people can.
Okay, so Jim handles all the subscriptions and he uses Mr. Bolens, MRBOLENS at protonmail.com. So this is for people that were already on the, he'll check your email against the list we have. So this is for not now. I'm not trying to make money doing that. I just want, I want more people to see there's a remedy. There's a, there's something you can do.
Yeah, and would you say that you kind of want people to like put put it together to like get something written and drafted so that you can at least know that they
And
were
that's the
able to do
thing.
that? It's
Yeah.
almost like you have to be able to do that to
Yeah, there's no excuse. I mean,
participate.
on a Thursday evening, if y'all shot me an email and said, "Hey, John, on Thursday, can I talk about? I just wrote up this pleading on the False Claims Act. What do you think about this?"
Mhm,
And then bring it up on the call. I'm more than happy to talk about that. But no one's done that. I mean, I think I even wrote the pleading for you.
mhm,
All you have to do is put in the facts. Yeah. So, anyways, I just was thinking about that the other day. So,
mhm.
I want to cover this, and there's anyways, we'll get into it. So, I want to ask about the question. Is the IRS gone, and what are the consequences? I don't see it being removed anytime soon. There's some real interesting concerns there because the tax code, as you're going to find out in this call and next week, and we've already discussed this before, the tax code protects data that the IRS, the US government already has. You're not going to repeal the entire tax code, okay? I think what you want is possibly judicial oversight. How about that? Maybe you also want to not be taxed if you make under $150,000 a year. No wage taxes. That can be changed. I think the code should be amended, and maybe Trump is going to do that. That takes legislation, so it does take time. Trump did put a hiring freeze on, these 88,000 new employees that we talked about a year and a half ago. That's done. Gone. That's gone. And I think he's removing people as well. So he's doing that through attrition, meaning that when someone quits or leaves the, job for whatever, he's not replaced. So that's going on right now. So the IRS is being stripped down quite well. So is the IRS gone? Well, maybe it may be at some point to a point where, yeah, you'll have less taxes, or you're not going to be taxed for tips and wages under 150 a year, or what are the other ones? There were some other things in there, tips and something like that.
They actually run a bunch of, he actually had a bunch of IRS agents fired on all the ones that were hired in the diversity program.
Yeah, he
Because
did.
when I was calling the I was talking to the IRS agent, and she was glad.
Yeah,
I mean, a bunch of them I talked to were glad. I
they
called
shouldn't be there. Yeah. Oh, you were telling me. Yeah, she was coming up
disclosure
with more
agents.
about it.
Yeah, disclosure agents on FOIA. I can do
Yeah.
freedom of information. Okay, so she had made a comment, and I just capitalized on it. I said, "What are you talking about?" And she said, "Oh, it says diversity." She said he got rid of them. He said they were dead weight, and they were paying him twice as much as all the other agents, and they were doing nothing but walking around
Wow.
transgender.
Yeah. Wow. Well, so that's some relief there.
There's
Yeah.
another article where they fired about 15,000, and their only job description was to hand out cell phones and laptops.
Yeah. Yeah. Good. So it's looking good. I mean, but talking about getting rid of the IRS, you're going to have a revised version of it. It's necessary. The thing we don't like about the IRS is that it has the police power. Okay, so think about what the IRS does. It's the accounting firm for the United States. And how many balance sheets does the United States have? Probably thousands, right? So we need it. We need some accounting function. We can have a private firm do it, I guess, but it's probably better if you have government employees doing the accounting for the United States. The thing we don't like about it is the audit process and the fact that the United States or the IRS agents themselves have been given police power. So what that means is under administrative law with police powers, that means that they can just upon notice can then take your stuff. I think that's where people mostly have the problem. So we can dramatically reduce the taxes if we adjust the trade deficit. If we fix that and we get rid of the fraud, abuse, and waste in government, we can dramatically reduce the amount of need for taxing people that work, that make this country work. So as far as getting rid of the IRS, I don't think it's ever going to be gone. Maybe they'll change the name or something so people feel better, but there's still going to be an accounting function. And maybe there should be judicial oversight. That's one thing. There should be less taxes on wages. Like the barrier for that should be over 150, right? If you're over 150, okay, tax your wages. And I don't care what the percent is. And then also, I think this is long overdue. We should get a private right of action for violations of the tax code and certain provisions. A private right of action. That means if you see a violation of the code, your remedy is not limited to just writing a letter to your congressman. You can actually sue them and get damages. That's what we need. We need a waiver of immunity with very clear conditions that basically you send notice to like the secretary and then you sue.
Mhm.
And that's a waiver, and then you'll see how quickly the agents behave themselves.
No kidding.
Oh,
Kidding.
private right of action. You want to take my house? Okay, I'll take your house.
Mhm.
Yep. So that's what I'm thinking there. So we're going to get into something, and I want to bring it up next week because when I was putting together this call, I saw that the subject is much bigger, and there's some new legislation coming, and I just want to incorporate that. And I wanted to not speak out of school. I want to read it again, and I understand the statutes very well, but I need to read this legislation because I'm liking it so far. It looks really good. I'm not going to get into it too far, but it has to do with privacy. There's some awareness, it looks like, in Congress on this matter, and I'm going to suggest some things that you may want to participate in regarding new changes to the tax code. And I think we should keep the tax code. It needs to be modified a little bit. But if the IRS isn't there, some other accounting function will be there. And there's still going to be an administrative law provision dealing with interacting with people. Okay, so we're still going to have that there. I think our big problem is not so much the IRS as it is the Financial Crimes Enforcement Network. I think FinCEN is a big problem.
Mm.
I think that should be abolished. But anyways, and maybe the ATF or something. But anyways, I don't want to get too far off track. But moving on to this, people ask me all the time, and this is a rhetorical question. In dealing with the IRS and the use of money, I always talk about company structures, trust organizations, contracts, divesting your exclusive rights. And so for 32 years, or actually about 30 years, really, I didn't figure this out until observing for a couple of years when people were getting annihilated by the IRS, thinking they could just set up a trust organization and then not have anything, right? Not have anything in their names, right? But that's not actually how you prevent the IRS from taking your stuff. The first thing is don't owe the IRS money, So what I realized is that if I look at 26 USC 6331, where the IRS has the administrative authority to take property of a taxpayer who owes money, but more importantly, take the rights to property of the taxpayer. The IRS could take your property and the rights to property. So if you have the right to spend money, the IRS can take it. So just because you're using a corporation to protect your property doesn't mean it's protected by the IRS. You could use a corporation. That's more complicated, and you're probably not going to find an attorney who will write your bylaws or amend the provisions of your corporate ownership in a way that would defeat an IRS levy, for example. Okay, lawyers won't do that. You have to understand how to do that. The understanding that I have over the years came from 26 USC 6331. So the solution is the common denominator in all the property that the IRS is taking. The reason why the IRS takes it is because you have it. It sounds so simple. So how do I not have it and still benefit from it? Well, I can divest my interest into a group. This is what I show people. So we get into the use of the limited liability company. And so people ask me, hey, John, is an LLC good to use? And I say, good to use for what? So first you want to find out what the heck you're trying to do.
Mhm.
Of course, anybody can set up an LLC and open a bank account, put your money in there, but what are you trying to do? Maybe you want to use the LLC to hold title to property. All right, so let's look at the problem first. Let's describe what that is and see if the LLC is a tool that can be used. In many cases, it is. Now, in few cases, a trust is more useful. I rarely write those. And then in some cases, a partnership is useful. Now, many times I'll take a partnership and I'll write it into the operating agreement because an LLC really is a partnership, or it could function that way. Now, here's the difference. Why do I want an LLC in most cases over anything else? Because the state law gives you protection against creditors. We call this charging order protection, where an owner of the LLC might have a liability to somebody. And the liability is maybe on his personal debt, let's say. And if the owner of the LLC is an owner with someone else in the LLC and that person is an innocent party, he doesn't have the joint liability with that one person, okay? The other owner, let's say two owner LLC. The first owner has let's say a credit card debt. Someone can get a judgment lien, a bank can get a judgment lien and levy on his property. You could take his personal bank account money, but he can't reach into the LLC and take the money because he doesn't have the exclusive right to spend the money. This comes back to 6331. So by using the LLC, I'm divesting somebody of his exclusive right. I'm taking it away and I'm placing it into a group. So where there's innocent parties, the IRS can't touch it. Now, you cannot do this just by adding a name to somebody's, like piece of real estate. It doesn't work because all titles or quitclaim deeds, unless you know how to write a quitclaim deed, are joint and several. So you have to be careful on those. You could do it in a quitclaim deed, but this is very sophisticated language and it's not worth getting into because then you don't have charging order protection and you have to know how to defend it and it costs money. So one of the rules I follow is avoiding costs of litigation. So again, go back to the LLC. Why do I avoid costs of litigation? Well, we know that as a matter of law, you have charging order protection, which I just explained. And so does a creditor's attorney, someone who gets a judgment lien against you, okay? So what he'll do is, most of the time, sometimes he doesn't, is if he gets a judgment lien against you and he's searching for your assets, he looks at your credit file, he looks on public records, and maybe he sees you're an owner in an LLC, okay? So he looks at the articles and he sees that you and your Uncle Bob are owners. He's going to stop. He's not going to look at that company. He's going to try to get your bank account, or he's going to sit on your house title if you didn't move it out of your name, or he's just going to sit on your credit. And for most people, they don't realize what that means until they go to sell their house, right? And then the creditor gets paid. And that's what attorneys do, mostly to avoid costs, additional costs. They just sit on your credit. They just put the lien there and they just wait for time to happen. And then most of the time they get paid out because people don't realize what's going on. So the LLC avoids cost of litigation. Now, here's what attorneys understand. Attorneys who are in the business of debt collections for banks and other creditors, and they're in this litigation, most of the time they understand the consumer protection laws. And as it turns out, for charging order protection, the way it works is like this. You get a judgment lien against a person, and let's say the person owns an LLC. And so you can apply to the court separately. Once you have the judgment, you can apply for what's called a charging order, or a writ of execution, or a levy, as we know it. This is not a wage garnishment. This is in addition to a wage garnishment. It's a levy on property, okay? Not a lien. It's a levy. That means I'm going to take it, all right? The court can award a charging order against the interest of the owner of the LLC. Now, the owner has a shared interest with somebody else, right? An innocent party. Not a spouse. It won't work with a spouse. It's an innocent party. That charging order is good. Now, the charging order says you can take X amount of dollars from this person against his interest in the LLC when he gets paid. So when money or property is transferred over to the owner of the LLC into his personal name, that's when it can be taken before he gets it. That's fair game, right? Here's the catch. If you don't do it, or you're not able to, let's say there's not a disbursement or not a complete disbursement of the writ of attachment, okay, the judgment lien, the charging order, okay, for the full value of the charging order. Excuse me. If they don't collect it, right? If the creditor and his attorney doesn't collect it by, let's say, December 31st or the end of the tax period, the creditor owes taxes on the amount of money that is not collected. It's like income. So I've never seen an attorney do this. He could, but he just doesn't. And I've seen tens of thousands of cases like that. So what this does is it just makes it to where I don't have to argue about this because someone's going to look at it in the public records. And an attorney who doesn't do that probably will be advised by the judge, even though the judges aren't supposed to do that. But imagine if an attorney does this, he thinks he's winning. I'm going to get a writ of attachment. He gets a writ of attachment, and the judge might say to him, "Are you sure you want that?" Because you're gambling on your ability to collect, because the owner of the LLC you're trying to collect against is with another party, and he can decide when he gets paid. Are you sure? Why don't you look somewhere else? So that's why I think it's so powerful. It's worked very well over the years. And I learned how to use it when people were already having huge problems, and I pulled them out of those problems and reorganized their situation many times using an LLC while also keeping everything else in place, their S corp and everything else they were using. So if you wanted to do this with a trust, imagine how you would get the protection, the same protection as you would with an LLC. First of all, a trust is not going to get charging order protection. You can write it in a way that defeats a collection. That's doable. Okay. The other thing you're not going to get with a trust that you will get with an LLC, which I almost forgot to mention, when you register an LLC with the state is going to indemnify you. So this is what you're getting. Charging order protection is indemnification from the state. That means protection against financial risk. That's why the creditor can't take your interest until you take the money out of the company. With a trust, can't do that. Your indemnification comes from how you write the and the beneficiary and the value of the property held within the trust. All that together, okay? You have to write the trust document in such a way that it will defeat a creditor from attaching the property. Now, here's the problem you run into. You may have costs of litigation because with a trust, even if you register it with the state, which is not necessary, the creditor's attorney can subpoena the trust document and pick it apart. And how much is that going to cost to defend it? And what happens if it wasn't written properly? You see? So sometimes, what they'll try to do is bust the trust, as you can imagine. So that's one reason why I don't use the trust all the time. Now, sometimes it's a good idea for, like, I call it an heirloom trust. If I'm going to use it to hold real estate, let's say the farm, okay? And I ask the client, do you have any plans on selling the farm? And if not, okay, fine. Let's transfer the title this way. And you can still get financing and all these things. And then we get into the other item, which is the partnerships. So partnerships goes back to the LLC. You can use a partnership. You have the same problem as trust. It can be done. I do the same technique or strategy for bylaws when I write them for corporations in foreign jurisdictions that don't recognize limited liability companies. So it can be done. It's a little bit arduous, but you can write a partnership agreement to divest a single person of exclusive rights over property. I've described this before, where two people come together, they put some cash together, and that cash makes more money, but they don't, under the contract, they're not allowed to take the money until certain conditions are met. So even though more money is made, there's no gain and none of it's attachable, okay? You can do that in the partnership agreement. You just have to know what you're doing. You have to understand when you're writing in the contract that someone has an exclusive right to spend money or sell property or dispose of property in some way, okay? If you have that, then you have exposure. And the best test is the Internal Revenue Code, all right, 6331. I keep mentioning that, but I'm also referring to other types of collections, DOE collections, student loans, credit card collections, any type of collection. If you can defeat the IRS and you can do it legally, which is what I'm describing here, then you've succeeded. And passes the test for everybody. Okay. Now, again, I recommend, like, if you have a partnership and it's working and you have a bank account for it and all that, that's fine. If you like the idea of using a limited liability company, here's what you're going to get out of that. Through the state's indemnification of you registering an LLC for your partnership. So your partnership becomes the operating agreement. Nobody gets to see it, by the way, only the partners. It's a private document. It should be proprietary. You're going to get the indemnification and you're going to get the charging order protection. That's what you're paying for. That's why you paid the filing fee. It's all about insurance. It's all about risk. Okay. That's what I like to talk about. So with that, I'll just, I'm not going to present any more on that, but if you guys have questions or want to discuss it, I know you each have different scenarios, situations you're working on. Okay. That pause there, no questions, but I know there's probably questions. Let me just say, next week, I'm going to talk about some privacy aspects, okay, with the tax code and the changes coming, and data privacy, okay? Things related to data privacy, which we've spoken about before. I think you're going to like it. There's some really cool things that we need to know about, and you can really benefit from this. So we can really help ourselves if we get ahead of this, all right? So that is going to be next week. It's kind of big. I didn't want to go too far today. I still want to do a little more research, but let's start with the questions. Karen, I think you were first.
Hi, John. How are you?
All right.
So I'm actually getting ready to file my annual. I organized my LLC a year ago, and I'm getting ready to file my annual report. And when I first organized it, I did hire a company because I didn't want our names on it. And so somebody else was the organizer. And I'm just realizing, are you still there, John?
I'm here. Yes.
Okay.
Yes.
I'm just realizing that when I file the annual report, I have to put an individual name and address that's different than the business as the person filing the report. And I do have a couple different addresses outside of my home address, but is there like the person that filed, do you have any tricks
All right.
to not
First of
use
all,
your own name?
you don't need a nominee organizer. That's not necessary. You don't need to pay for that. You could just literally use a fictitious name, but you're not getting privacy this way. There's no privacy this way. You can have another person's name in there, but you could have just written a fictitious name in there. You can write a fictitious name in for the registered agent, and you can write a fictitious name in for when you submit the new annual report.
Okay.
You can certainly do that because even though it's under penalty of perjury, you're not defrauding anybody.
Mm-hmm.
So you don't need to pay for someone else to do that. Now, as far as address goes, are you talking about the registered agent address, or are you talking about the principal address of the business?
Well, I did find a registered agent for $35 a year, which
Okay.
I just
That's
use
fine.
that.
Yep.
So it's more about the individual that is filing this report. And right now it has to, I
You can use
I
a
haven't
fictitious
hired it.
name.
Okay.
You can use a fictitious name because let's say you hired someone for a day and then fired them. It's not important. You're not defrauding anybody. Okay, it's not an issue of fraud. You can just use a fictitious name if you want to do it that way. And you're not, by the way, putting your name on there is not an issue of privacy. You don't
Yeah.
have privacy when you're interacting with the state in this way.
Yes.
A lot of reasons why. So there are other ways to have privacy. The address you put on the articles, no one is going to look that up and send you important mail. You're going to get mail where you tell people to send, mail to your company.
Mm-hmm. Okay. Okay. I used to have an LLC in Texas, and this was years ago, and we just used our home address. We didn't know
Yeah.
any better, and we got so many offers, and we still
Yeah.
do to this day. So
Yeah.
I don't want to get the junk mail.
Well, I have a strategy for dealing with the mail that you don't want. You can segregate the mail that you want from the mail that you don't want. What I like to do is I tell my friends and family and business partners, hey, look, this is my address. It's a PO box, right?
Mhm.
Then I from then that I get all the mail then that I don't want at my house. And by the way, I don't use my real name for my mail. Why should I? I don't have to. If I order something from Amazon, I have it sent to a fictitious name, or it's a
Okay.
gift, right? But
Okay.
what I do then is I do an official change of address notification with the Postal Service online, and that dumps all the mail that I don't want anyways to wherever I tell the IRS to send it. If I tell the IRS I'm moving to North Carolina, some apartment complex, then that's where it goes, and it's
Mm.
gone. Until, maybe somehow your name and address gets associated together again, but you could do it
Mhm.
that way as well.
Okay. Okay. Well, thank you for those
Okay.
tips. That's
All right.
helpful.
Thanks, Karen. All right, Jacob, were you next, huh?
Hey, yeah,
Yeah.
John,
Go ahead,
what's
yeah.
the discoverability of a trust?
Well, discoverability, well, first of all, there has to be relevance. It has to be admissible and all this sort of thing. And usually it passes the test. So discoverability has to do with the trust corpus. The trust, the beneficiary's rights and duties, and the trustee's rights and duties.
Right, right. But if, say, someone, for whatever reason, let's just say a payment processor, merchant cards, or Amazon is looking to sue me and they look me up, what's the discoverability of if I have a trust? Can they even find it?
Okay, so a merchant processor is going to do what? Sue you?
It could be anything. It could be like it could be the IRS. It could be, yeah, like a merchant payment servicer. It could be anything.
Well,
If
that's a
they're
bank
going
account.
through the
That's a
public
bank account,
records.
and they act on data you give them. So you have to decide what data you're going to give them. How are you going to do that?
Ah, I see. So they can basically, even if a trust, so you're saying basically
Why
My,
using a
infor-
trust anyway?
my
You're using a trust
information ends up in a bank underneath the trust.
No, no. How are you using the trust? Is the trust the merchant account holder?
No, no, not at all. I'm just using the merchant account provider
Well, then that would, so between you and the merchant,
as a creditor.
if you
Just an
personally have,
example.
if you personally have a merchant account
Yeah.
and let's say there's a debt collection, because that's what would happen. And then
Yeah.
let's say you didn't pay the fees or something and you close your account and stop doing that, whatever it was. So the merchant processor would, let's say, sue you or have a debt collector sue you, and the data you gave it would be the data it acts upon. Your association with a trust would be irrelevant.
So trust wouldn't even be discoverable necessarily.
Discoverable, but it's not relevant and they don't care. Nobody cares. How does that help them in the collection process? You owe the money.
Well, I mean, they're all about collecting money. So if I'm associated with that trust and that's my property, then it's fair game. I
Well,
would
let's
say
talk
it's
about
very,
post-judgment discovery. Let's be real specific. This will cover everything and be real specific. Post-judgment discovery. Someone sues you, gets a judgment lien. Now
okay.
you have your property rights held in other structures and whatnot. And yeah, it's all discoverable. You can be asked, let's say no one knows about it, right? You can
Yeah.
be called into a deposition and ask questions under oath. Do you have an
Oh.
interest in, trust? This is what people don't understand. So
Yeah.
it's discoverable to the extent that you have to answer that question, and you can make it not discoverable. You can make it subject to, it's not subject to discovery if it's written properly.
I understand.
Like, for
Yeah.
example, let's say I'm the trustee for really someone else's property. Most people that I'm talking to here that we're on these calls, they're a trustee for their own property. They're not, it's all self-dealing, right? But if you're have a job and you're the trustee at a church or something for other people's property, that is certainly not discoverable. It has nothing to do with your personal interest, right?
I totally agree. Yeah, I understand. But what I hear you saying is discoverability. If you're under deposition and people are asking you questions, then depending on that puts you in a very
You have to be careful about it.
tight
Yeah,
spot,
you have to be
because
careful. This is where people start. Okay, they start with the wrong idea that if they're using a trust to own property, I hear them tell me things like, I have a trust. So when you're talking like that, and then you get a question, do you have a trust? People say, yeah. And there is no such thing as I have a trust. If I'm a trustee of property,
Yeah.
for the benefit of beneficiaries, and I'm being sued in another capacity, my individual capacity, my role as trustee is irrelevant to the proceedings. So if I'm asked that question,
That's right.
yeah.
Yeah,
I mean,
that's right.
Right. So if I'm asked, like, if they ask me, do you have a trust? I would say no.
Absolutely. Yeah. And you wouldn't be lying either, because it's
Right.
not yours. You're just serving as a
I've
trustee.
done hundreds of those. So you have to be careful. You have to understand what you're doing.
Yeah.
And the question, a lot of times lawyers don't even know how to ask the question. So that's helpful. But
I
pretty
love
much-
that. I
Pretty
love
much
that
everything
video.
is subject to discovery. Which one?
Right. Everything's subject to discovery. I love that video, that deposition that you sent a link out. And it was of that one rapper, little tiny something, but it was a deposition. It was his deposition. And he was so amazing in answering those questions.
Yeah, you really have to think it through. The way I answer questions, I coach my clients is I answer things that I can't lie about. They know that they already know the answer, right? So,
Yeah.
okay, you got me on that one. But then questions they can never prove, I tell them whatever's necessary.
Yeah.
So, but yeah, you gotta think it through. Be very clear about, your relationship to property and property rights, because even if the property rights aren't there, if it appears to exist, lawyers will claw their way over and get you to say certain things and then say, aha, and they get the judge to, let them attach it. So you got to be careful.
Yeah, absolutely. I guess my whole point is that, if there is if the trust is set up properly, then there's really no way that it's discoverable
It can be.
unless
It can be. Yeah, you can have a bulletproof trust. There's a lot of strategies. Certainly, we can even do a whole series on that one. So, but again, I don't like, it's too complicated and it doesn't totally eliminate cost of litigation. That's why I usually avoid it unless I'm not going to deal with cash flow. If I'm just going to hold some property, then it seems to be okay. Many times I'll have a client that's got all kinds of drama going on. And so I don't even read the trust. What I'll do is I'll replace the trustee with an LLC and make that the trustee.
Interesting.
That's another strategy. That way I don't need to go into the inner workings of the trust. That's his problem, you know. But I will solve his problem by replacing the trustee. After that, he should go back to the whoever wrote the trust for him, you know, if I get a case like that. If I write the trust, then it's already baked in there, you know.
Got it. Okay, thank you.
Yeah, all righty. iPhone 2.
Hi, John. Can you hear me?
Yep.
Okay, so I am looking to buy a van and I don't want it in my name. So I was thinking a PMA, maybe an LLC. Originally I was thinking a PMA with my son, just because based on what you had said in another Zoom call previously. But what do you think for something like that?
The benefit you're going to get out of owning a car that's not in your name is not a corporate structure or something for like normal asset protection. It would be for solely for privacy, and I would use a fictitious name.
Is that cash only?
It doesn't matter. If the bank's involved, you can still use a fictitious name. Just let them know what you're doing. Just tell the dealer what you're doing, let the bank know, and they'll probably, you know, probably talk to a couple of people, but yeah, you can put it in a fictitious name. It's easier
Okay.
with cash, but yeah, that's what I would do because you're not going to get other benefits because creditors are not going to take your car or your truck unless you're like, you know, driving some antique or something like that, or it's really valuable, or you filed bankruptcy or something. No one cares.
Okay. All right. Well, see, because I was thinking even if you pay cash with the dealer, they have like a IRS form that they have to fill out.
Okay.
But
They're going to do that. They're going to need your legal name for that one. You can't get around that one. That's why I always like to structure. Here's what you do. If you're paying cash, it's so simple. If you're paying cash, you know you're paying cash. All you do is tell the dealer it's a loan. You don't have to tell them it's cash. Make it look like a loan. And then wherever you're getting the cash from, you know, give them the name of the company. It's your company, right? If it's cash from your personal account, use the name of an LLC as the lender. Or your Uncle Bob. It doesn't matter. That way, whatever name you're using, by the way, becomes the lien holder. He'll write up all the documents for you. You can even use your home address for everything. So if you're paying cash, that's fine. That's for you to know. You don't have to tell the dealer that. You can avoid all.
I think like my main thing was I didn't want that filing. I didn't want that notification
Okay, well then
for
just
cash.
do what I just described.
Okay.
You know it's cash, but the dealer doesn't need to know that. All he needs to know is he's getting money for the car. You tell him that, you know, you have the money wired from your lender, which is you.
Okay.
Then he's not going to do the IRS report. You see how simple
Okay.
that is.
Okay, I still might need to get with you beforehand just to make
Okay, all right.
sure.
All right.
Okay, thank you. Thank
Okay.
you.
Hey, John, there are a couple of questions in the
Oh,
chat, and
thanks.
since
Yeah.
you're talking about fictitious names, can a nominee be fictitious? And the question is, do we have to worry about being able to prove our link to the fictitious name? And if so, what are the best ways to do that?
In many cases, a nominee, there's no, either we'll do one or the other. Nominee, fictitious name, one or the other. Nominee is a real person who's using his real name or a corporate name or something. It's a real name. Fictitious name, I always make sure everybody I'm dealing with knows it's a fictitious name. It's no problem. I just want to make it to where that record of that transaction, that relationship does not connect my legal name to whatever data is important. So you're not trying to like trick everybody. You're just making it where when you make a record and it goes out into the world, it's got the wrong name with the correct information and the contract is still valid. That's when so I don't know if you give me a more specific example, I can probably, you know, give you a better answer.
Mm.
And someone asked me, Eli was asking me if I filed an FCA case. No, I'm doing it for clients. I haven't filed it yet. I've got 2 lined up.
Mm-hmm. Here's another question. How does the PMA impact the LLC?
It doesn't. A PMA and association can be the owner of the LLC. I don't know. It's not considered when the LLC is interacting with the world. It's just your manner of ownership. Like think of it like this. If myself and my brother were the owner of an LLC, okay, so now it's a 2-member LLC, multi-member LLC. So my brother and I are a PMA already. No one else can be in that association. It's very exclusive, right? My brother and myself, okay? So what if we called it, the Singleton Brothers PMA? All right. So I just gave my brother and I a group name, and we listed that as the sole owner of the LLC. That's it. And so now the LLC does not have charging order protection, but it's an innocent party that owns it. And if anyone were to investigate it, they would determine that it has a charging order protection. It would just create the need to defend it, you see? So there's different ways of looking at that.
Here's another question. What
Are you
happens if vendors or banks keep asking us to disclose our beneficial owners for the LLC during KYB?
Yeah, do it. You want to disclose the beneficial interest unless you have 5 people own it or more. If you have 5 people or more own it listed in the articles, the bank's not going to ask you for that. The bank may ask the signer for that information. So it's not a problem to disclose the identity of the beneficial owners. You're going to have to do that. You're not losing your protections by doing that. Remember, the account holder is the LLC. It doesn't matter what information you give the bank. That's why we use it that way.
I think this is a follow-up to the previous question. So say you're before a judge trying to get charging order protection, and the judge says, well, hang on a second, the registration info doesn't link you at all. Prove you're the owner. What do you do?
You don't do that. You're not
I'm
trying to get,
confused by
you're not
that.
using a judge to get charging order protection. You don't have to do anything. You have it once you have an LLC registered. You don't have to go to a judge to get it. Let me see if Dale has a question. Hey, Dale.
How's it going? Yeah,
Hey.
so I opened a checking account for a business checking account for my LLC today at the bank. The bank manager made me sign the BOI, the Business Owner Information Form.
Yeah.
So at this point, the corporate veil has been pierced. Is there any advantage in not filing with FinCEN at this point?
Yeah, make sure they're not having you file something that's going to get filed with FinCEN. Make sure it's not a second document where you're signing your BOI information for your relation to the company under penalty of perjury. Don't do that. Don't let the banks do that to you. Refuse that. Don't let them report something in your behalf to the FinCEN creatures.
Okay, thanks.
I think they're trying to get it in the back door. I've heard this several times already.
Here's a question. What if you have a nominee that is 0% beneficial owner? Do they need to be disclosed?
Okay, so this is called a non-member manager. And yeah, the bank is going to ask for his identifying information. That's fine. That's fine. Non-member manager, that's no problem. I don't normally write them that way. Sometimes, but mostly it's member managed.
The person who asked the question before about the judge, he's saying, what I'm actually saying is, you're before a judge or a banker, and they say, prove you're the owner and have the authority to do something.
Okay, so what'll happen is the attorney would have already subpoenaed the articles and the operating agreement. The articles are public record, but the operating agreement is not. So before you even get to that point, there's going to be discovery of these documents, okay? And if the attorney will be trying to pierce that relationship. So the way I write the operating agreement is for a worst case scenario where you are in this situation and someone's trying to get your property from the company and break through the charging order protection, as if your company doesn't exist, right? So I've written it in such a way that it should survive like anything. It's impossible. They're not going to, because the rights, the way I've expressed them, do not give the creditor the ability to tag your interest, because your interest is not tabulated. That's how I've written it mostly. So that's what would happen. So a discovery request, starting with the operating agreement, I would look at the discovery request. I would have to look at the case file, and then I would look at the operating agreement and make sure that it's not exposed anywhere. And if it is exposed, I'll revise it and send the revised version in. Anybody want to ask me if that's okay?
Is that okay to do?
Is that okay?
Yeah, because the date we got the subpoena, we were actually revising the operating agreement because it's a business practice, normal business practice. And they wouldn't know anyways. But they wouldn't know anyways.
How many members were in it?
So,
Oh, you're gone.
all right. I think, all right, we're back. All right. So let's see. Yeah. All right. Yeah, there's lots of posts over here. All right.
We went
Any
through a lot of
questions?
them.
Yeah. Any good questions there, Moko?
Well, I asked them already. If someone has a question that hasn't been answered,
Okay.
post it again, but I think we've been doing it as you've been
Oh,
going along.
super. Appreciate that.
Yeah.
Yeah, so that's what I want to present, but I hope you tune in next week. I think it's I'm a geek. It's probably not interesting, but those of you who are here, you're probably like me. I would just want to share with you what we have coming, which is legislation that may be very favorable to new technology, the use of new technology, and the data collection with the IRS. If you haven't placed a lien on your data with the IRS, I recommend you do. But also get involved in the call next week because I'm going to go over some things that are pretty good. I've never seen this before. Some smart people are writing some laws. I love it. And I want to suggest some things that we can do in the meantime before these laws that are proposed right now that we can actually get our Congress critters to go in there and put some good stuff in there for us. All right. It's already good, but I think there's some more things that need to be in there. Okay. So I want to cover that next week. I was kind of big. I didn't want to, you've heard me talk about 6103 before with the FinCEN situation, but that's only part of it. It wasn't necessary to talk about the rest of it. So this next week, I figured, okay, let's do that because there's some really cool stuff coming down, and I want to bring in some other statutes that are very similar to the 6103.
What did you read that we should maybe read to be ready for the next class?
Well, I'll
The
bring it up.
proposed legislation.
I don't
Okay.
want to spoil it. I'll bring it
Oh,
up,
okay.
but I will tell you that, okay, so if you look at my definition of your private identifying information in the security agreement, if you look at my definition, you'll see it's almost identical to this new piece of legislation. Someone is paying attention.
Wow.
I've never seen this before. Most Congress critters they're not in reality. They just write things that you're thinking, well, that's so vague, but this covers it. So I'm really excited to talk about that. So okay. Well, John, if you're saying when all three roles in the trust are the same person, it's a PMA, I'm going to tell you that it's not a trust. And I will tell you that a PMA can operate as a trust. So, I mean, it's just, someone's going to make a determination. If you guys want to look up what the criteria are for a trust, you can see the case law on that. That'll help guide you. That's how I do it. I always ask, who are you holding property for and what's the benefit, right? It's always property is held for the benefit of others, right? A trust is formed for the benefit of the beneficiaries. That's what a trust is. Yeah. Yeah.
Someone's asking, what points would you hit with a security agreement? What points would you hit with a security agreement for a bank?
The bank. I would make the bank the debtor.
Mm-hmm.
That's it. Take the security agreement, and if you like the definition of your property there, you can't add to it. Just make the bank the debtor and record it. Yeah.
Could you explain what do you mean by make the bank the debtor?
Well, if the bank is collecting your identifying information and you record a security agreement identifying the information as your property, that makes the bank the borrower, the debtor, the licensee under the terms of the security agreement.
Thank you.
Yeah.
Can you remind people where they can find your security agreement, series?
Yeah, thanks. Over at aceofcoins.club, you can see there's a series there that I talk about the security agreement, how to use it, how to write it, all these things. I think I even have the document up there if you guys want to use it. And I really encourage you to share it with other people and even teach them how to do it. You don't need me involved. It's already written. Once you understand how it's working, you should be able to do it yourself. And I'm telling you, each of you should have like 30 or 40 filed. 30 or 40, you'd be surprised. You got the DMV, the IRS, all these government agencies, you got your phones, your ISP.
Mm-hmm.
Oh, the list is so long.
And then also like the big boys, like Intellius or whatever, those guys, right?
Yeah, I mean, you know, there's services out there like we talked
Credit
about.
aggregators or whatever.
Yeah, there's aggregators. Oh my gosh. There's services that, yeah, you can, like Intellius is a great one. Look on the internet and find out where your data is being collected, who has it. TransUnion,
Mhm.
Equifax, Experian,
Equifax, yeah, all those
yeah,
guys.
LexisNexis.
Mhm.
Yeah, that's a big one. All right, I'm gonna go over this next week.
Great.
I just didn't want to throw it out there.
Uh-huh.
I'm not trying to be mysterious. I would like to give you guys a quality presentation with some points, okay? That's just how I like to do stuff. So anyways, I hope this is, you know, useful to you, and please pick a fight. Make a claim under the False Claims Act. Come on. You got friends. Your government is behind you. Pam Bondi doesn't know about the False Claims Act. I listened to him talking about stuff, and they're talking about situations where the False Claims Act would come in, and they're missing it. They're not looking at it as a remedy. They're not discussing it. They're not seeing this. We need to teach them. It's our government. File a claim, pick one, go after Nancy Pelosi. It's fun. You'll get in the news cycle. Get her for 80 million. No joke. Look at all these NGOs out there. How many NGOs? So anyways, the security agreement. Okay, the security agreement covers all your data privacy, okay? All the property rights you have over your data, your identifying information. That's what I'm covering. All right, does that help you guys? Anything else?
Thank you.
I hope that was
Very
good and useful.
interesting.
I didn't want to go too long tonight, but almost an hour. Wow, okay. All right, well,
That's
that's all I
fine.
have to offer.
Thank you so much.
Thanks for joining. Appreciate you guys
Yeah.
joining.
Thank you so much and
Enjoy
happy
your weekend.
Easter.
All righty,
Thank you.
good night.
John, can
Yep.
I just have a quick one there, please, John, before you go?
Yeah, go ahead.
We were back and forth. We were back and forth in relation to the private ruling with the ATO, and I'd sent you a couple of emails, and I haven't received any response. I'm just wondering if you
Yeah. I see
I
your
corrected those
request there.
documents.
What I need help with is I need how your ATO is going to ask you to request a determination of something. There's a procedure, and I don't know what that is. You can't just write a letter because we're just wasting our time. There's got to be a way you can ask for a legal determination. There's a procedure and an office you got to address it to. If you can show me the taxing statute law, I can probably find it.
I did send that through, and there's two ways. One is by letter, obviously, and the other one is an online form. But I want to stay. I want to stay away from the online form.
Okay. All right. So you have the actual rule to follow and the formatting for the request. We got the right office, right? They can make legal determinations.
Yeah. Yep. Got their
Okay.
address.
Let me
Everything's
check it
right
out
there.
again.
It was in that.
All right.
Okay. Awesome.
Yeah,
Thanks, mate.
thanks for your
Because I'd really
patience.
like to get it.
Yeah.
No problems. Thanks, John.
I hear you. All right. Thanks. Y'all have a good night.
You too. Take care.
See you, mate.